There's like some populate the room song, which I'm definitely not going to sing for you guys. All right, everybody. Well, we'll go ahead and get started as everybody is joining us. I'm Angela Tyner. I'm the Advocacy Director here at Georgia CASA. I've been with CASA going on 17 years now. I'm an attorney by trade, a child welfare law specialist. I was a CASA volunteer while in law school, so shared some similarities with some of you there. With my role at CASA, I do a lot of trainings for staff and volunteers on the courtroom advocacy side, work with juvenile court judges and some of our other partners, and strengthening advocacy and legal representation for children and parents, and excited to be with Jerry today doing this webinar for you guys. So as folks are joining us, just a couple of logistical comments. We had a record-breaking number of folks register, so we'll see how many end up with us. But please use, if you have questions, please use the chat feature. I don't know if you can see the QA, but we'll be really managing the chat. So put your questions in there. We'll try to get to them either while we're presenting or near the end if we have time. I know we'll be watching our pace. We have a little bit of an ambitious content agenda for us. A couple of other things at the end. As you're closing out Zoom, you'll get a link for an evaluation. We'd appreciate if you fill it out and let us know what you thought, what other topics would be of interest or helpful to you in your advocacy role. The presentation is being recorded. We will send out afterwards, and I'm sure we'll get this question probably 3 or 4 times in the chat, but we will send out both the link to the recording as well as these slides, and then a couple of other materials afterwards. And then the last thing that I'll say before we jump in is that if you're a volunteer and you're maybe most interested in how you're going to get your 1.5 hours of in-service credit, we won't be issuing any certificates, but just tell your volunteer coordinator, your supervisor, that you were part of this webinar today, and we'll make sure that you get your hours. All right, so this topic on best interest advocacy and courtroom advocacy has been a staple of our routine in-service opportunities we've been offering for a long time. We have done them for staff and volunteers, sometimes combined, sometimes separately. They used to be live trainings back pre-COVID, pre-pandemic times, when we would do them live regionally at the state conference. But this is really a unique opportunity to be able to do this as a webinar for everybody. And so many people are getting to hear in this statewide audience the same information at the same time. And that's really, I think, our primary purpose today, is we're really, when we talk about strengthening advocacy for our kids in foster care, we're really trying to make practice more consistent across jurisdictions. And really, we've had it's not a new juvenile code anymore, but we've had a juvenile code in Georgia that's been in place 6 going on like 7 years. And one of the things that the code lacks is guidance about the role of the guardian ad litem and the role of CASA and how that should be exercised. And that's led to not only disparity in practice from county to county, but also in disparities in outcomes for children and families. So kind of recognizing that and getting the same questions from CASAs and judges and attorneys over and over again. Over the course of the last year, Jerry and I have been working on a best interest advocacy guide. I can't even see if I'm going to be holding it up, and it's going to be in the frame, but for judges and practitioners and others, in terms of really looking at strengthening advocacy, offering best practices for the role of the GAL and a full inclusion of the proceedings. And to that end, we've been going through and updating our trainings and really revisiting this topic across the state and our various disciplines. So if you guys are interested in reading that guide, all 80 pages of light reading, we'll refer to it several times throughout the day, and we'll email that out with the slides and the presentation too. So I am going to turn it over to Jerry to allow him to introduce himself and his role in the state, and then also to kind of start us off with why we're starting from a constitutional context.
Hey, I'm Jerry Bruce. I think I know a lot of you already, but in case I don't, I'm currently the director of our state court improvement program, which is called the Georgia Supreme Court Committee on Justice for Children. And our job, our mandate from the Georgia Supreme Court is to work on improving the law, practice, and policy in our juvenile courts, both in all the kinds of cases that our juvenile courts hear. Most of our work revolves around dependency cases because that's what most of the juvenile courts work centers on, and that's where most of our manpower, laws, and efforts reside. So we talk a lot about those sorts of issues. I was a juvenile court judge before that. I was a SAG before that. And I've also been a prosecutor as well. And then I've had some times here and there where I've represented private clients in juvenile court and other courts as well. So I think I've done a lot of different work in juvenile courts and have seen the different sides of juvenile court that a lawyer can see anyway. So I hope that this combined experience that I have, and with Angela's experience as well, can help you get a better grasp on what it means to be a best interest advocate in juvenile court and how best to approach that. So we always start with the civil liberty interest whenever we start talking about these cases, because you have to have this constitutional framework. This is something that a lot of courts don't talk a lot about. A lot of lawyers who come into juvenile court and never get trained on this because you don't have to have any real prior experience to be a juvenile court judge or to be a lawyer in juvenile court. In my experience as both a SAG and as a judge practicing in juvenile courts in Georgia, the people with the most training before they walked in the door were first casas, and after that defects workers, and then way down the line you would have lawyers and judges. I mean, you might have lawyers and judges who had had lots of experience in this area before, but it's not necessarily so. It's not required like it is for casas and to a lesser extent for defects employees. So this framework needs to be emphasized for everybody, and that is that when the state is involved, when the state, so defects is a state actor in a constitutional sense, when defects gets involved in the family relationship, the parent-child relationship, there's a federal and state constitutional implication. That constitutional the right to family integrity is protected by the liberty interest of the federal and state constitution. So that's the same interest that's protected in our criminal laws, because there's a state intervention in your personal liberty. This is a state intervention in your personal liberty to have a family and to have your family organized the way that you see fit and to rear your children in the way that you see fit. And so there's a real balancing act that has to take place whenever the state gets involved in that constitutionally protected relationship between parents and their children. And the US Supreme Court has recognized this for over 150 years. We've had cases coming all the way down into the 2000s that continually restate this constitutional liberty interest. So we have to be careful that whenever there's a state attempt to intervene in family and children's lives, that it's only in the most severe cases, only in the cases necessary to prevent severe harm to children. We don't want to be in the business of getting involved in people's lives because we don't happen to like their socioeconomic standards, or they don't live as well as we live, or things like that. We're only going to get involved in the most severe case and only to protect the life and health of the child, and not simply to improve the child's outcomes. That's not the job of the juvenile court. The job is to protect those children. We do hope that in doing that, we can provide tools that'll help the families and their children improve their lives and improve their outcomes. But that's not our primary goal. Our primary goal is child protection. So we always start with this idea of the liberty interest. Sometimes when we're talking to guardians ad litem, or GALs for short, and remember that CASAs only have one role in our juvenile court system in Georgia, and that is as a GAL. We've had some courts, unfortunately, that didn't read the law, or just simply decided not to use it, which is a bad idea for courts. We've had some courts that have decided in cases that there are CASAs who can be used not as GALs, but as some sort of, I like to call it a fairy godparent. Georgia CASA does not endorse that term, but it's this idea that I've got this CASA out here who's going to sort of just, make the child's dreams come true. And while that would be wonderful, it's not the statutory role of the CASA. The statutory role of the CASA is to be a lay guardian ad litem. So your job is to advocate for the best interest of the child in the ways that we're going to talk about going forward. So CASAs, whether they're attorneys, or the GALs, whether they're attorneys or CASAs, sometimes have concerns about how the best interest of children should be balanced against the rights of parents. We hear this a lot, where they'll say, I feel like the parents have all these rights, And those rights outweigh the best interest of the child. And we need to be really careful about that because we're talking about apples and oranges when we do that. We have to remember as we go forward that what this constitutionally protected liberty interest guarantees is that the rights of the parent and the child, it belongs to all the family. It's a right to family integrity. So it's not just the parents, it's the parents and the child have this right to be free from government interference in their private arrangements. And what that guarantees them is a fair process. So parental and child's rights guarantee them a fair, open, and transparent process in juvenile court. It means that they have rights to an attorney, that they have rights to confront the witnesses called to testify against them, just like defendants in criminal cases do because of that same constitutionally protected liberty interest. They have rights to have expedited hearings, to get hearings done quickly, and to get orders that are clear and concise and give them clear direction, and that are limited in their intervention into the family just to those aspects of the family dynamic that are necessary to reduce the harm to the child. So that's what the rights of the parent and the child guarantee. They don't guarantee any particular outcome. Because the parents have rights doesn't mean the parents win the case or that the child wins the case. It just means that everyone has a right to a fair, open, due process. The procedure is fair and transparent, and we hope expedited so that we can get a child to permanency quickly. The best interest question that we're going to talk more about is a question about outcome. So assuming we've had a fair process, assuming we've had a fair trial, assuming we've had ample notice of hearings, proper representation by counsel, zealous and informed advocacy by the lawyers and the GALs in the case, and that the court makes appropriate findings of fact and conclusions of law. So assuming we've done all that, then we're in a position to have all appropriate evidence in front of us to make a determination about which outcome is in the best interest of the child. So best interest deals with specific outcomes when you've developed evidence using those due process rights. So the rights don't guarantee any particular outcome, they just guarantee a fair procedure. So we never balance the rights of the parents or of the parties at all against the best interest of the child. They answered completely different questions. So just try to keep that in mind as you go forward, and it may help keep things a little more clear.
Yeah, so I guess I'm up next, and I have several quotes on here that if you knew me and if you knew the folks who said these things, that they're part of my work crushes, and I could start to geek out a little bit. But that this concept of family integrity isn't just Jerry and I talking about. It's not just a Georgia CASA, the court improvement project or program, but it's coming from the Constitution. It's coming from the feds. It's coming from our Court of Appeals, that we're looking at this context that the parents' rights and the child's best interest aren't in competition. And that really when we look at a child's best interest, we have to start that analysis in the context of the child and their desires, their unique circumstances, because that's how we're going to keep it objective and based on the facts at hand and the evidence that's presented and from the child's vantage point, and not substituting our judgment or our values that are in play. So this next one has some guiding principles on here, and I think these guiding principles are shared by many of us, but actually National CASA has put these out, and as they have issued their new local program standards, and really calls on the CASA network, not just in Georgia, of course, but across the country, to really provide best interest advocacy for children as reflected in the guiding principles, recognizing the importance of family preservation, reunification, equity, diversity, inclusion, and collaboration. So the guiding principles and the way that we would want to approach our advocacy as we get started from the very beginning is that we understand the trauma that comes from removing a child from their parents, that it's in the best interest of the child to remain in their family of origin with their parents whenever it's safely possible, that as we're advocating for the best interest of the child, we're celebrating the parents' strengths and what they're able to accomplish in their case plans and on their journey to rehabilitate and get their kids back. That if kids can't be reunified with their parents, that when we're advocating for permanency, that we're seeking permanency options that are going to preserve connections with their family whenever possible, and that we treat termination of parental rights not as the first go-to option, but as an option of last resort when that parent-child relationship is irretrievably broken. And as we look at these values and these principles in our advocacy, all of it is under that lens of recognizing diversity, equity, and inclusion, and that the experience of all of our kids should be the same and not have different outcomes based on how they look. And my guiding principle is that ultimately casas, we are change makers for children in foster care. We are able to transform their experience and care. We're able to that end, help transform their future, their family's future. And it's a really powerful role that you guys are embarking upon when you take that oath by your juvenile court judge and get admitted. So this is kind of segueing into the role of the GAL and the role of the CASA. So we always like to start with our federal law, the Child Abuse Prevention and Treatment Act, that gives us the authority to advocate on behalf of children, and that requires that a guardian ad litem be appointed for a child who's been a victim of abuse or neglect. CAPTA was enacted in 1974, really, really recently when you think about the the age of our country. But believe it or not, 40, however many years ago, that this was the first federal law, the first law that was really seeking to make states consistent in their practices in these cases. And since the very first kind of federal law looking to make practice consistent across the country was requiring a guardian ad litem for a child with a very specific role of conducting an assessment, getting a firsthand view of what was going in the child's life in order to make a recommendation, make that best interest recommendation. Since the 96 amendment of CAPTA, because these federal laws need to be reauthorized from time to time, has required or has allowed an attorney or a CASA to serve in that guardian ad litem capacity. So Jerry, I'll let you talk. You kind of got into it a little bit already, but about the role of the GAL and the difference between an attorney and a CASA serving in that role. Did you see the comment? Somebody said, do parents, are these rights consistent from county to county? Is this the same from county to county? I was like,
Yes,
so.
We have a statewide juvenile code and the rules apply everywhere from county to county. One of my least favorite things is to go someplace to watch court and hear this sort of, well, we don't really do that here. We have a local practice here. And I always say, look, local practice is like, we start court at 8:30 instead of 9 o'clock. Local practice is we have a calendar call at 9 and 1. Local practice is not we don't follow the law here, right? Because our juvenile code applies in all the 159 counties of Georgia, even the ones that are a really long way from Atlanta. The ones that are closer to Tallahassee than Atlanta still applies. So these rights and the things that we're talking about today apply in all the counties of Georgia. So we are getting some questions, and the ones that tie right in with what we're talking about, we'll probably jump right into. It may be that some of them are kind of outside the scope of what we're talking about. We have a question about, since we're talking about parental rights, how does doing court via Zoom affect the legality of severing parental rights? We don't have a definitive legal answer to that question yet. A lot of courts in Georgia are extremely hesitant to terminate parental rights via Zoom because there may be problems with the confrontation of witnesses. We don't know yet. We don't have a definitive answer to whether having court via Zoom inhibits the ability of parents or children to confront the witnesses called to testify. So we don't know yet. We'll find out.
And if we don't get to your question during this, at the very last slide, we'll have our email addresses. You can email us and we'll get back to you, and we'll have a transcript of this chat too. We can go back and see what we missed.
Yeah. So, and it's appropriate because we have a question about whether the GAL role differs between the attorney and CASA if you have an attorney and a CASA operating as a GAL on the same case. So first, let's just define what a GAL is. A GAL is someone appointed by the court, an officer of the court, whose job, after receiving special training, you saw that CAPTA slide, both Georgia and federal law require that anyone serving as a GAL in juvenile court have specialized training before they do so. And then that person, after receiving that training, is sworn in by the court, either as a lawyer at the time they're sworn in as a lawyer or as a CASA at the time they're sworn in as a CASA, with the specific duty of being an officer of the court whose job is to advocate for the child's best interests in the case. So we can have attorneys serving as GAL, and we can have lay people serving as GALs, non-attorneys. And attorneys who are GALs get to do all the things that attorneys do. We had a case like that came up recently, 2018, that said, look, just because you're a lawyer serving as a GAL doesn't mean that you're not still a lawyer. You can still do all those things that lawyers do, like objecting to evidence, objecting to testimony, filing motions, making arguments, those kinds of things, calling witnesses. Lay GALs can't do those things. Lay GALs can't do anything that might be construed as the practice of law. But other than that, they have exactly the same role. And it's possible to have a lay GAL and an attorney GAL on the same case. It may not be a great idea, but it's certainly possible. And if that's the case, they both have exactly the same role in that case. Sometimes courts appoint the child's attorney as the child's guardian ad litem as well, and they appoint a casa. Most of the time when courts do that, practically speaking across the state, that child's attorney who's duly appointed as a GAL is really just acting as the child's attorney. It may be that the judge appoints that person as a GAL as well, because without that GAL order, the attorney can't get the child's educational or medical records, for instance. That's a process that I used sometimes when I was a judge, because having an appointment order as a lawyer didn't get that lawyer all the information that the GAL order got them. Those lawyers were really primarily functioning as lawyers and not as GALs. But it is possible to have more than one GAL in a case. I guess you could have, a dozen GALs if the court really wanted to. Although at some point you begin to really question the wisdom of doing that. So, what's a casa? A casa is just a specific brand of lay guardian ad litem. That's all casas. I said it's all casas are. That's a lot, but that's what casas are. Casas aren't anything else. They're not special investigators appointed by the court to go and tell the court, what's really going on here. They're not just there to fulfill the child's wishes. That's what the child's attorney is there for. If the child can communicate those to the attorney. The casa is a particular brand of lay guardian ad litem. And so the duties of the casa are exactly the same as those of any other GAL, whether they're lay or attorney. So casa and lay GAL mean the same thing. So most of the time in these presentations, we just say GAL, because the best practices are generally the same for a lawyer GAL or a casa GAL. Okay, so we want to be really clear about that. The GAL, whether casa or lawyer, has extremely broad powers to affect the outcome of the case if those powers are properly used. I mean, I said a minute ago that if I have an order appointing me an attorney in a case, I don't necessarily get an immediate response from school officials, medical personnel, or others if I go to them and ask for that child's records to help me prepare for the case, even though I clearly have a right to those under Georgia law. But the GAL order is usually responded to immediately because it's very clear in our juvenile code that the GAL gets access to all of the information, all the facts and circumstances surrounding the child's case. The GAL order is extremely powerful. So the GAL has an extremely broad role. I think the GAL role in our current statute is one of the most powerful advocacy roles in the courtroom, but it has to be effectively used. There has to be advocacy going on before, during, and after hearings. And that's one of the things we're going to talk about going forward is exactly how you do that.
So I'll interrupt Jerry for just a second before he goes back into talking about our role as an officer of the court, just to remind everybody about our statutory responsibilities in exercising that role. Not a lot of guidance on how to do it, but clear about 17 aspects that comprise our advocacy. And we could spend the whole training just on these 17 items, but just a couple that I want to point out to you in the context of what we're talking about today. Of course, the first one, right? Our role of maintaining regular and in-person contact with a child. And this is an area where CASA as a GAL, I think, really surpasses any of the other players who might serve in the GAL role, because we're meeting with a child face-to-face, not just before court, but on a regular basis, usually once every 30 days, and have that opportunity to develop that connection and really have an intimate understanding about what's going on. Couple of those on there, number 4 and 5, talking about the GAL's role is in communicating with the child's attorney and with the other folks during their assessment. We're going to talk a little bit about that. We're going to talk about our access to information and the records that we're required to be reviewing. But I do want to point out number 8. As Jerry is saying, that we have one of the most powerful advocacy roles in the courtroom, and that the purpose of the juvenile code is to ensure that the best interests of the child are of paramount concern. The judge is required to make best interest findings every stage of the proceedings. That makes the role of the GAL invaluable, and really more than that, necessary in order to proceed. So number 8, attending all court hearings and other proceedings to advocate for the child. It's so important to make what efforts you can to be able to, in your schedules, to be able to be in court for those hearings, being able to advocate for the children and families there. A couple of others here, the advocating for timely hearings and requesting a review of the case. But know that those are your cards in your pocket, right? When we're talking about promoting permanency and getting the children what they need, and in that assessment, that one of our roles is to make sure that the court hearings are staying on track, and that if there is something that comes up that would need to arise to the court's attention, that we're seeking a hearing, even if one isn't already scheduled. And then the last thing that I'll point out, because we're going to talk about the GAL's responsibility to submit a written report at every hearing, that the code outlines some minimum content that should be in there with regards to not just making recommendations, but reporting specifically on the parties and respondents' compliance with case plan and court orders, making recommendations, talking about the child's degree of participation in visits. So if you follow our CPRS template, you'll get all the information you need and more, but know that there is a statutory minimum to that requirement of what's in the paper or what's in your report.
Okay, so I said earlier that the GAL is an officer of the court. We're going to talk about who the players are. So we talk about parties a lot. And so the parties to the dependency case, and when we say dependency case, we mean dependency or TPR or any other kind of case that might flow out of one of those cases. So the parties are the parent or parents, the child or children, and the state. So those are the parties to a dependency case. There's a possibility for private cases. Private individuals can file dependency cases. Our code allows it, but it doesn't really provide a framework for how those cases are supposed to go forward. And even though they happen, they're not the normal way that dependency matters get raised by courts. Usually this is going to happen when DFACS requests a removal on an emergency basis, or perhaps files a petition asking the court to intervene for some reason. So the parties are the parents, the children, and the state, because they have rights at stake. They're the ones who have something to lose basically in the outcome of the case. With the parents and the child, it's obviously their relationship, their custodial relationship, and their actual interpersonal relationship. And with the state, it's the state's requirement to ensure the safety of the children who reside in the state. So they all have rights that are at stake. So the GAL, whether a casa or a lawyer, is not a party. And because the GAL doesn't have any rights at stake. The GAL obviously will care a lot after doing an assessment and looking at the facts and circumstances of the case about how the case comes out. But even though the GAL may be emotionally invested, perhaps, and we'll talk about that going forward, the GAL doesn't have any rights at stake in the case. The GAL doesn't have any custody that's going to be impaired or anything like that. The GAL doesn't have a public policy of child protection and enforcement that the GAL is required to uphold. So the GAL is not a party. Some people think that's not a good thing, but in fact, it turns out to be a much better thing that the GAL is not a party, but an officer of the court. It's also true that the relatives of the children and parents are not parties to the case, and the foster parents are not parties to the case. Now, they all may have important roles to play in a case as current placements. Foster parents are obviously current placements for children. Relatives may be potential future placements for children. They may be current placements for children too. But unless the court gives one of those parties custody or allows one of those parties to intervene in the case, which is something we really don't have the scope to talk about today and really is not that common in Georgia. Those people are not parties. They may be useful, they may be helpful resources, but they're not parties either. On the other hand, they don't have anything like the power that the GAL has in the case. Unlike the foster parents and other relatives and people who might provide help for the family or resources or placement, the GAL is not just someone out there waiting to assist. The GAL is an officer of the court who's been appointed by the court with these broad powers to affect the outcome of the case. So it's really important that the GAL is not a party, and we'll keep that distinction in mind as we go forward. So I want to talk about the motivations of the parties and of the judge to begin with. So we would expect that judges are very impartial, right? We want judges to be impartial. They're required by law and by the Code of Judicial Conduct in Georgia to be impartial, which means that they don't have a stake in the outcome of the case. So when I was a judge and I'm sitting and listening to a case, I don't have a stake in the outcome of the case. I might feel strongly about the outcome of the case, but I don't have any objective stake in that case. What I have to do is discern what the evidence is, and then as the judge, I'm required to do what the evidence demands, even if I don't like the outcome, right? So that's an extremely important thing. Judges don't just get to do what they like in cases. There were many times when I felt in my gut, perhaps, that a child had been subject to abuse or neglect, but there was not sufficient evidence on the record for me to find that. Well, I was not at liberty. I was bound by law and by the canons of judicial ethics not to find the child dependent if the evidence didn't allow me to. I was required to live or die by the evidence and to say there's not sufficient evidence for this. On the other hand, there were cases I can remember where I felt that it didn't really rise to the level of a removal and maybe shouldn't have been a removal, but there was ample evidence that pointed to a removal necessity, and I might have ordered a removal even in a case where I wished I didn't have to order a removal. So that's what we mean by impartiality. Now, the parties are advocates. They're not impartial. We don't expect them to be impartial. You're the attorney for the state, or you're the attorney for the child, or the attorney for the parents. You're not impartial. You have an idea, probably from the very moment the case starts, exactly how you want that case to come out. And you are going to work to achieve the outcome that you want to achieve, regardless of what the evidence looks like. The GAL, when you put the GAL in this mix, the GAL has aspects that are in common with both the parties' representatives, that's the lawyers usually, and with the court, right? So the GAL is required to advocate. Both CAPA and state law says that a GAL is appointed to advocate for the child's best interests. But unlike the parties, the GAL is required to look at the evidence in the case, and in order to come up with an objective best interest determination, do what the evidence demands, even though the GAL might not like the outcome. So you're usually going to have parties' representatives. The parties are going to be telling that representative to advocate for the outcome they want. They're never going to tell them to advocate for an outcome they don't want. Whereas the GAL may have to advocate for a position the GAL personally finds distressing because the evidence doesn't support it, just like the judge. But once the GAL comes down on a decision about what the evidence is pointing to and what the best interest factors require, the GAL is going to advocate heartily for that outcome. The difference is that if the evidence changes, the GAL may change the outcome. They may say, oh, now that I hear more evidence, I'm going to have to change my recommendation. GALs may come into a hearing with a recommendation ready. They should come into a hearing with a recommendation ready. And then if the new evidence arises at the hearing, they should be prepared to change their recommendation if that evidence rises to the level of changing what's in the child's best interest. So the GAL, like the court, is going to be following the evidence, but they're going to be advocating for what the evidence demands rather than just looking at that evidence impartially like the judge. So we call this impartial advocacy. And what this means is that, as I said, the parties approach evidence with kind of utilitarian motives. If I've got the evidence that, mom was in a certain place on a certain day and it might look bad for mom, I might decide that what I'm going to try to do is minimize that evidence. I don't want the judge to hear that evidence. Maybe I'll try to keep it out, or maybe I'll find other evidence to contradict it. So they don't really care whether that evidence is reliable or not. What they want to know is, what's it going to do for their case? Does it help or hurt their case? And then if it hurts their case, what can they do to minimize it or exclude it? They're not interested in just having the judge hear all the facts, really. The parties are interested in having the judge hear their version of facts. That's why we have an adversary system. But the GAL is gathering information in order to diagnose really what's in the child's best interests. And what they want is to know what the most reliable version of the facts are, what the most reliable version of the facts is. And they're gonna go forward with that version of the facts. So they're interested in the objective nature of the evidence, and they're not just trying to use the evidence. So one of the things that GALs have to do is gather information. They have to gather lots of information. The parties have to gather lots of information too. They should, to be getting ready for court. But the GAL has got, again, a certain requirement. The GAL is required to meet regularly. These are some examples from the things that Angela just pointed out. Meet regularly with the child to gain information. Consult with the child's attorney. Provide assessments of the defects, permanency, and treatment plans. Communicate with all the professionals who are providing services in the case. Monitoring compliance of the parties with the case plan and court orders, things like that. So they're going to be gathering a lot of information. Notice too that right there, just as a side note, where it says monitor compliance with the case plan and all court orders. I've seen CASAs who act as if that means monitor the parent's compliance with the case plan, but they have to monitor the compliance, as the bullet right before that says, the compliance of DFACS and the parents with court orders and treatment plans. DFACS is required to do things under case plans and court orders, and one of the jobs of the GAL is to ask, is DFACS doing what it's supposed to be doing? Are they really providing meaningful services in the case? Are they really doing the casework that needs to be done? Are they taking a very proactive approach to getting permanency in this case, or are they letting the case drift? So it's not just the parents' compliance with court orders, it's DFACS and the parents' compliance with court orders. But so they're doing this, back to the main point, gathering lots of information. But in the end, they're supposed to provide reports to the court and the parties. That means they're gathering this information for the purpose of sharing it with the parties. The parties may have information that they have to share under discovery requests, which we'll talk about a little bit later, but they don't by nature have to share the information they gather. They may have information that they gather that they don't want to share, that they want to keep close to their vest, and they're not under any obligation necessarily to provide that information to the other parties, absent a formal discovery request. So they're not gathering information to share, they're gathering information to use to make the case look like they want it to look to the judge. You're gathering information to share with all the parties so that they have all the information they need, and so that the court has all the information it needs to determine what's best for the child.
Yeah, listen for you.
So the GAL can't comply with the statutory duties and responsibilities that person has under our code unless they share the facts and circumstances that they gain in their investigation or assessment with the court and with the parties. We can't have a case in which the GAL just stands up and says, yes, no, I agree with DFACS. I disagree with DFACS. Judge, I don't want you to do this. They have to say why. And they have to tell how that request, either to do what DFACS wants or not do what DFACS wants, or do what the parents want or not what they want, why that's related to the facts and information they've discovered in their case, which is why GALs are required in most types of hearings to provide written reports to the court and to the parties. So they're gathering information so that they can share it with the parties, and so that the parties will then understand the factual basis for the GAL's recommendation regarding the child. One thing we have to keep in mind, though, is that there is a limit on the sharing of this information. The information gathered by the GAL in the course of a case must be kept confidential. That means that it can't be improperly disclosed. What does that mean? Well, confidentiality protections don't apply within the case itself. right? So that doesn't apply to the parties. The parties are already bound by confidentiality. Everybody in a defects case, for instance, is bound by confidentiality for that information. The GAL is required by the code to share the information through written and oral reports with the parties and to tell them what's going on. So that's not a violation of confidentiality. That's not an inappropriate disclosure. That's a required activity. What's problematic is when the GAL shares what the GAL has learned with people who are not parties. So with relatives, with foster parents. Foster parents may need certain information. They have to get that information either from the court or from defects with whom they have a contractual arrangement. They can't get that information, if it's confidential information, directly from the GAL. Can't share that information with service providers, for instance, if they don't already have it. Certainly can't share it with people in your house. Can't leave your files lying around where they could be seen by other people. So that's really important to remember. So you can't refuse to share with the parents and their attorneys, the child and his or her attorney, or the state and its attorney because of confidentiality concerns. Anything you gather as a GAL, they have a right to see.
So we are having some questions coming in, and I know we're going to talk more about in the next couple of slides about sharing that information with the parties. But we have some questions coming in about the CASA's or GAL's ability to access that information, right? And your appointment order and the role of the guardian ad litem in the context of those court proceedings has the opportunity to have really broad access in our statute to be able to access even health and education records and all of even personal protected health information about a child and family. When DFACS isn't complying or folks aren't wanting to give it to you as a volunteer, the best thing to do is to go to your coordinator and help them and let them help you navigate. Because sometimes it's not that somebody's trying to block your access to it, but just has a gazillion things on their plate and just needs some gentle reminders about sharing that information with you guys. We've had a question, and they're scrolling through. I don't know if I'll be able to move them up or down, but about accessing the juvenile code. If you wanted to look at it, I was like, oh, it's on the state homepage and the legislature homepage, and they've completely revamped their website. I was looking at it, so I don't see it there. But maybe
if you Google Georgia Code online, you can find
it'll bring it to the Lexis version.
I think it's the Lexis
not the
version.
Just Jars. Yeah. Okay. All right.
Google Georgia Code online and you can find the Georgia Code, and you can have an exciting evening. You can make yourself a nice drink. You can sit back and read the law. It's fun.
And we are looking, our juvenile code dependency stuff, right, is going to be in chapter 11 of title 15. So if you start 15-11-1 and kind of go from there, you'll be able to see everything to do with juvenile court, whether it's dependency, delinquency, CHINs, TPR, all of it.
Yeah, Secretary of State's website.
All right, so Jen has it up. Is there anything else that, oh, it's not touch screen. Any other questions that maybe we have missed? I know there was also a question about if when the child's returned home, does the roles and responsibilities of the GAL change? It should not. Unless the child's circumstances are make it impossible, that role of the GAL stays the same.
If anybody has access to information that you believe you need, your court order gives you that information. If you're not getting it, then please speak to your staff, because they should have avenues set up to help you get that info. Ultimately, what has to happen is you got to get that information to the court and let the court know that you're not getting the information you need, because then the court's GAL order is being circumvented, and the court will want to know about that. But you'll have some sort of workflow that's been worked out between your staff and the court about how to get that information to the court.
Couple of other things, a quick opportunity to highlight the quick reference guides, the access to information, QRG, they're on CPRS. If you aren't sure where they are, they're probably with your pre-service training manual, but that access to information card really outlines what you as a CASA or as a GAL has access to. Something like that, those copies of the drug screens and a person's compliance with treatment, that kind of has a heightened level of being able to access the information, but you still are entitled to get that information. So just know that use your QRGs. That'll help you know what you have access to as well.
So I said a minute ago that not only the GAL, but the parties need information to get ready for their cases as well. And the normal way that lawyers gain access to information to get ready for court hearings is called discovery. If you've ever been involved in a lawsuit, which I hope you haven't, you may have had an experience with the discovery request. Someone may have asked you for copies of telephone records, bank records, employment records, any number of things that they might need in order to help them prepare their case. They can get all kinds of information in normal civil cases. Discovery in juvenile court cases is highly restricted. It's not as nearly as liberal as it is in general civil cases. And parties are going to be making discovery requests much less frequently in juvenile cases. One thing that really shouldn't happen normally is that the parties should not have to make a discovery request to the GAL. Hey, the GAL has access to information, judge, that we need, and we're not getting it, because the GAL should be sharing routinely anything that the GAL discovers. It says that the GAL is supposed to provide those written reports. Well, those written reports that they get, we hope in advance of the hearing, are going to say, I looked at assessment A and B, and I looked at evaluation C, and I looked at these things, and these helped me make my decision. Well, those assessments and evaluations should be available to the parties so they can look at them as well if they don't already have them. There's really nothing that the GAL can look at that the parties don't have a right ultimately to have access to as well. So the GAL should be sharing all that information with them. And also, the GALs are required to encourage settlement of cases when necessary. And one of the ways to do that is to sit down with the parties and say, look, here's the information I've gotten. This is not really something we want to go into court and argue about. Look what this assessment says. Do you really want to go into court and have to deal with the consequences of this assessment? Let's find a way to settle this case. So they're going to be sharing information as GALs that they find with the party. So it should be extremely unusual that a party in the case, the parent's child or the defect SAG, should be making a discovery request to the GAL. If that happens, though, what do you do? What happens if you get a discovery request? Well, the Georgia Court of Appeals has said that there's no absolute privilege in a guardian ad litem's file. What has to happen is something called an in-camera inspection. So even if the parties in your case make this request for your file or for stuff in your file, what normally has to happen is that the court has to look through that information first to make sure that they have access, that they have a right to have access to them. They're almost always going to have a right to have access to them in your case, which is why you should almost never be faced with this situation. You shouldn't be withholding information. They shouldn't believe you have information that you haven't disclosed to them. Normally when this arises is when there's some other case going on. For instance, there's a divorce case or a custody case in superior court, and somebody wants to know what you found out in juvenile court and how that might help them with their custody case in superior court or something like that. That's a case where you can't disclose the contents of your file outside the scope of that juvenile court case. Remember, because everybody inside that bubble, the parents, the child, the state, the guardian ad litem, are all bound by the same confidentiality rules. That doesn't apply to people in another court or in another case. So if someone asks you for a copy of your file or sends you a subpoena, the first thing you need to do is contact your staff right away and let them help you navigate this. But ultimately, you need to know that you can't disclose the information in your file in another court or in another case unless the judge in that case, that court in that case, first reviews your file to determine whether it's appropriate to release the information to those parties. Once you have an order from a judge in a superior court case or some other court case saying, release this information, you're completely protected. But if you release that information without the court order, then you could be liable for civil or criminal penalties. You don't want to do that. So if you get a subpoena or a request for a review of your file from someone in another case or another court, please talk immediately with your staff and let them know that. So again, I think I've already covered this stuff in this slide before we even got to this slide.
No.
But the order requiring you to disclose this information has to come from the court in which the information is sought, right? Not the juvenile court, unless it's the juvenile court in which that case is sought. So if it's a superior court case, somebody in a superior court case wants access to your file, it's the superior court judge presiding over that case who has to say disclosure. So you don't want to do this. You don't want to disclose that information in those cases or otherwise without a court order first.
No, and thank you for breaking that down. Like when you get that, if you are served with a subpoena, if you do get that motion or request for production of documents, the first thing is just to go to your coordinator. Their first thing, they're probably going to call me. Like if experience serves, that's going to be the first thing that ends up happening. We actually, in this room a couple of months ago in November, did an entire presentation for the coordinators and directors CASA programs about access to information and the proper disclosure. So that is, I think, archived on the intranet if you were interested in checking it out. So the big thing is just not to ignore it, because you don't want to be in contempt of anything just because you ignore those deadlines that are on there. So we're going to kind of just quickly talk a little bit, as we're in this context, a gathering to share about our communication with the court and with the child and with the other attorneys, right? Because juvenile court is, Jerry said in the beginning about in terms of the proceedings and being adversarial, but both with our guiding principles and just with everybody having the best interest of the child and family at heart, really to be more collaborative in nature, right? But when it comes to communicating with the court itself, let's just talk a minute about ex parte communication. The juvenile code prohibits ex parte communication by the GAL. So even though we're not a party, it's expressly stated that meaning that the GAL or the CASA can't go have a conversation with the court outside the presence of the other parties or their party representative, their counsel, right? And why is that? Is because you deprive the absent party of their opportunity to be heard, right? And that the party who is having that private communication may get a tactical or procedural advantage, and we just don't want to do that. If on accident, maybe you were to communicate with the court, they would likely disclose it to the other parties and be able to move forward after that disclosure. But sometimes it could lead to where the judge has to recuse themselves, a new judge coming on the case. I mean, you just don't want to get into that situation at all. I will keep going. Jerry probably has his own stories. I mean, sometimes, and I think it's easy. I think the CASAs, I'd like to think that the CASAs are pretty good about knowing not to communicate with the courts themselves, although sometimes maybe there's some slip ups. But I have the anecdotes on the other side where the CASA is leaving court and the judge is knocking on the CASA's window saying, like, well, what about that case today, and things like that. So
don't have those conversations with the court.
All right. See, that's easy. We're moving right along.
Judge, I can't talk to you unless all the other parties are here.
Picking up a couple of extra minutes. Ex parte is bad, right? Now, on the flip side, collaborating with the child's attorney is actually one of those 17 rules and responsibilities that I outlined earlier, right? And required by the code. But the level of collaboration, the level of conversation that you're going to have is really going to be contingent on whether or not that attorney is operating as a guardian ad litem, like you, in a kind of that hybrid role, or if they are straight up appointed as a child's attorney and representing the child's wishes and stated interests. But the point is to the extent possible, when you can collaborate and assist each other, even if it's an attorney GAL or a dual role attorney, that it's not duplicative, right? You each have your strengths, and to the extent that you can assist to each other will really help move that case forward. I think Jerry will talk a little bit later about how you want to, if you have information or facts that would support your recommendation and you want it presented as evidence, how do you get that evidence before the court, right? And that's one of those ways that even during the hearing, if you're sitting close to the child's attorney or if you strategize in advance of the hearing, that you can help get that information in. With regards to communicating with the child, who obviously is a party to the case, right? I really just want to highlight a couple of points, because while every child in Georgia has an attorney appointed to them, whether serving as a GAL or otherwise, the chances are is that the child or youth is going to see you more frequently than they see the attorney, and that you might be the first one who's explaining your role as GAL to the child, and being able to do that in kind of an age appropriate and developmentally appropriate way, but also distinguishing your role from the attorney, right? That your information is to gather, your role is to gather that information and share it with the court. That what the child tells you is not going to be confidential. It is going to be provided to the court and parties, versus their attorney, who is able to be in that privileged kind of communication role with them. The other thing is discussing the hearing that's coming up, what the court's going to be deciding, setting realistic expectations, ascertaining whether or not the child wants to be there, advocating for the child to be present if in fact they are comfortable and want to be present. One of the benefits of Zoom court or remote or virtual court, whatever platform that you guys are using, is it is easier for everyone to be able to participate. And a child's not missing a day of school to travel, but knowing that it is part of your role to advocate and ahead of time in advance to allow the child to be able to participate in their hearing if they want to do so. On the flip side, if the child's there and you're thinking, whoa, they don't need to hear what's about to come out, right? Asking the court, totally appropriate to do so, that you think, while this one witness is questioned or for this particular piece of the hearing, that it would be in the best interest of the child to step out and not hear that part. So just remembering those pieces. So we're going to move into, and kind of watching our clock here, we're about 35 minutes late, or 35 minutes left, talking a little bit more about our best interest recommendations. So I'll be remiss, even as we're talking about our best interest advocacy, to not remind you guys of the factors. I saw that Lori put in the chat box for us the link to the quick reference guides, that of course one of the very first one is listing out the best interest factors. There are 20 of them that the court is required to consider. We have entire trainings just on these, so we won't go into detail on them today, but really the takeaway for you is that the code requires both the court, when we talk about our similarities with an impartiality with the court, that the court requires both the attorney or both the judge as well as the GAL to consider and evaluate all of the factors in the context of the child's age and developmental stage, right? That when our role is to do an assessment of the facts and then make a recommendation, both by CAPA, both by our state law, but that we really need to sift our recommendations through the best interest factors. And that helps make sure that we're removing any opinion, any preferences, really checking ourselves for that implicit bias, all the things that we talk about with our guiding principles and how we started out, right? So the factors are objectifying our recommendations. If you use CPRS to write your court report, we try to make it really easy that when you're making in your recommendation sections, that we are numbering the best interest factors and say, look at this factor, look at that factor, look at that factor, to help support your recommendations. When I do court observations, when I review your CASA reports, it's probably the number one thing that I note for the staff and for your coordinators, is to really make sure that when you're writing your recommendations, you're using those best interest factors to help support them. On the flip side, it also helps you to know what to recommend too. If you're like, oh, I've done this entire assessment and I've looked at all this information, I don't even know where I'm at, looking at those best interest factors will help to guide your recommendation. So I'll turn it over to Jerry to talk a little bit more about the written and oral reports.
Right. Because the one thing we want to avoid is, so CASAs and GALs in general have to have specialized training. So they're not just people pulled in off the street who are then shown a lot of evidence and asked to tell us what they feel, right? Oh, I really feel like this child should go here or there. I mean, you're going to feel something about the case. The question is, what do you think about the case based on the evidence you've seen? And can you justify, using the evidence and the best interest factors, your recommendation? So we don't just want your gut reaction. We want the code requires you to have a considered, evaluative reaction that's based on looking at the facts of the case that you've discovered or that you've heard in hearings from the evidence, and then looking at them through the lens of the best interest factors, and then using the result to come up with the recommendation. Again, like I said before, sometimes the recommendation may be something that you don't like. Maybe you wished you could recommend something different, but that's a sign of a good, zealous, impartial advocate. just like it's a sign of a good judge to sometimes do orders that the judge feels, uncomfortable with because the evidence demands them. So keep that in mind, please. And that's one of the reasons why the code requires that at most types of hearings, the GAL has to present a written report, because it's really difficult to show how the best interest factors apply to the evidence you've gathered in an oral report. It's not impossible, but it's much more difficult to do that. And a lot of times we hear guardians ad litem called on by the court, and they'll say, okay, let's hear from the guardian ad litem. And the guardian ad litem will say, my least favorite guardian ad litem thing, no objections to what defects wants, judge. Okay, that's not a guardian ad litem report. The other thing that I like even less is when the judge says, does the guardian ad litem have anything to say? And the guardian ad litem says no. There should never be a time when the GAL doesn't have something to say, even if it's just to highlight portions of a written report. The reports should never be thought to speak for themselves. The GAL should feel free to stand up and elucidate, to illuminate why the recommendation looks the way it does, and to highlight important parts of that recommendation, because the court may have just skimmed it. The parties may have read it, they may not have. It's important not simply to stand on the recommendation as written in your report, because one of the things that's happened since you filed that report is that you've sat through a hearing. And the parties in the court have a right to know how the evidence that came out at the hearing affects the recommendation. What about all this stuff we just heard over the last 3 hours? Does that affect the outcome at all? You need to be prepared to answer that question and to tell the court, now what I've heard today doesn't affect my recommendation. Why? Here's why. I didn't find this to be very believable or something, or this doesn't bear on the questions I've raised in my recommendation. Or, yes, judge, I think after hearing these things, I may need to reconsider my recommendation, and I may need to make a different recommendation. The code says that the written report is not available to be admitted in evidence at adjudicatory hearings. So normally an adjudicatory hearing is that first hearing that's supposed to occur. We used to call them a 10-day hearing, within 15 days of the preliminary protective hearing. That first hearing where the court determines for formally whether the child's been abused or neglected and what to do with the child. The other one is the termination of parental rights hearing. Those are both adjudicatory hearings at which all the rules of evidence apply. And that means that hearsay is not admissible at those hearings. That is something that somebody said outside of court, repeated to the court in court, without that person being there who made that statement. So guardian ad litem's reports will necessarily, a lot of times, contain hearsay. I talked to this person said this. I talked to that person said that. So those reports may not be admissible at those hearings. And so the GAL needs to stand up and make an oral report at those hearings, because the court has to hear from the GAL at every hearing to advocate for the child's best interest. So you should never say, judge, I don't have anything to say today. And I can't tender my report, so I'm not going to say anything. So for all those reasons, the GAL needs to be prepared to make an oral report. Maybe you're at a hearing where your written report wouldn't be admissible, and maybe you're at a hearing where your written report now needs to be supplemented for the court and the parties by what you've heard at the hearing.
Yeah, I would, and we'll flip to the next one, but just being ready to highlight something from your report that hasn't come up from another party that that's important to the child, but that really giving that recommendation supported by the best interest factors is part of your role, even if you have a thorough written report. There was a question about that I said CPRS, and I didn't mean to speak any jargon. If you weren't familiar with that, that acronym, that means that you don't write your reports in that format, but the court process reporting system. But about half of our CASA programs use that program in order to write their CASA reports. And there's some pre-populated prompts to help you make your recommendations. Some of you guys might use it only to access the case plan or other information about the case. But we can send out what the template looks like or what those prompts are guiding you to, even if you don't use CPRS for your court reports.
If you want to use CPRS, you can. So just let Angela know, and she can let me know, and we can set you up with access to CPRS. So
want to talk about the best interest factors in JG, I guess.
In the end,
got interrupted.
The best interest of the child is going to be a really big question. It shouldn't be something, those factors, those 20 factors, deal with every aspect of the child's life, really. and all the child's relationships and current situations of bonding and the child's needs and desires together. So it's a really big question, and it's not something that can be answered by a judge, I just stand on my report, or a judge, I have nothing to say. It's got to really be jumped into feet first by the GAL every time the GAL gets a chance to do it. I mean, the facts and circumstances surrounding the case, which is what the code requires the GAL to delve into to help formulate this recommendation, deal with things like, was the child actually abused or neglected? You could say, Judge, after reviewing all this stuff and listening to the evidence I have here today, I don't believe the child's been subject to abuse or neglect. And in that case, I can't make a recommendation that the child be removed from the home because I just don't believe that. And that's an important thing to keep in mind. You never get to assume that the child has been abused or neglected. That's always the state's burden to show that. And you don't have to concern yourself with the levels of proof and the burden of proof. The question is, after listening to the evidence, are you convinced that the child has been abused or neglected? Or are you wavering and doubtful about whether the child has been abused or neglected? And if you have a doubt, you should always resolve that doubt in favor of the parent-child relationship because it's a constitutionally protected liberty interest, even if you're personally not really comfortable with that outcome. So what we could boil this down to say is that the best interest factors don't even come into play unless there's evidence of present dependency. If there's insufficient evidence to support either the initial removal or if it's already been removed, the continued removal of the child, then the best interest of the child is presumed to be that the child's going to remain with or return to the parent. So you always have to ask yourself that, am I satisfied by this evidence that I've heard? Am I convinced? Not just do I think there's sort of a chance, but you have to ask yourself, am I convinced that this child has been subject to abuse or neglect, one, and that two, there's no way the child can be safely maintained in the home. Because you can have a dependency case where you believe a child has been abused or neglected, but you believe it's perfectly appropriate for the child to be returned to the home with certain safeguards in place. That's one of the alternatives that the court has at the end of every hearing, is to return the child home. So finding abuse or neglect does not necessarily mean the child has to be removed or that removal has to continue. So those are the things you have to ask yourself. You're not going to be making a best interest determination if you don't believe the evidence rises to those levels. You're going to be saying, Judge, the best interest of this child is to remain with the parent. So we want to talk about an illustration from an actual case. There's a lot of facts to this case, so I'll go through it pretty quickly. This was a case where the mother actually poisoned the father and the child. So not a good day at that household. The dad, realizing what has happened, grabs the child and rushes to the hospital. And when he got to the hospital seeking help for himself and his child, DFACS sought an emergency order to remove the child from both the mother and the father's custody, even though the father had attempted to protect the child and himself by taking the child to the hospital when the mother had tried to kill him. So now that the father, for his good work, has to answer a dependency case, and he appears, he doesn't have a lawyer. The court did not have the appropriate conversation with the father about his right to go forward without a lawyer. So he just decided to go forward, and he said, sure, I'll stipulate that the child is dependent, which was really a bad idea because at this point, there's no dependency because that father, there's nothing to show that that father can't properly take care of the child, right? He's done, based on the facts we have, he's taken real efforts to protect the health of himself and the child. But he goes in because he doesn't know any better. He doesn't have a lawyer. He stipulates the child's dependent, and the court leaves the child in DFACS custody. Now dad gets a lawyer, and the lawyer comes in and says, we have to withdraw this agreement. He didn't know what he was talking about. And then DFACS, after having reviewed the case, their lawyer says, we can't stipulate that this child, we can't agree that this child is dependent. We believe that there is no dependency for this child because this child has a parent, namely the father, who is perfectly willing and able to take care of this child. We've gotten DNA evidence to show he is the father of the child. He's currently not living with poisonous mom. He's residing with his brother and his niece, and he has current employment. That home is appropriate. He's not using drugs. He had some criminal history, but it was a long time ago, and he's never been convicted of anything that was bad. He had a child molestation charge, but that child molestation charge was found to be not supportable by evidence, and he was reduced to a misdemeanor battery a long time before this. So it had no connection with what was going on today. And so DFAC says, Judge, we've got to return this child. We can't keep the child in our custody because there's no evidence of dependency. The CASA in this case recommended not only that the child should stay in DFAC's custody, but that reunification services should be stopped. It was like one of the most drastic outcomes in a case. And the court ultimately relying, it seems, very heavily on the CASA recommendation. You know, we say that GALs have really broad power and authority in courts. We mean it. I mean, a lot of courts rely very heavily on the recommendation of the GAL. And here it seems that the GAL single-handedly swung the court's decision-making to leaving this child with a grandmother and not providing any reunification services. And the Court of Appeals was frankly extremely puzzled as to how the CASA, looking at the best interest factors and the evidence in this case, could have come up with this recommendation. The record showed that the rationale the CASA gave for this recommendation was to say, well, I can't verify the father's living arrangements in place of employment. Not that he doesn't have those living arrangements in place of employment, but that I, the CASA, haven't been able to verify them. Those are different things. Why would you recommend that a father not have his child simply because you haven't been able to verify his living arrangements in place of employment? The court mentioned in its final order that it got a full report from the CASA recommending placement with the maternal grandfather, saying that the biological father had failed a drug test and had an extensive criminal record. In fact, the court's order wasn't able to show that any of those things were true. He didn't have an extensive criminal record. He had not failed a drug test. And there were no facts to support this recommendation for non-reunification and placement with the grandmother. So this was a case where a lot of time was wasted because the court entered an order that was not supported by the evidence, driven in large part, it seems, by the recommendation of a CASA who ignored the evidence and did a sloppy job of applying the evidence to the best interest factors. Because in fact, what you had was a father that this CASA may not have wanted to come over and have dinner at this CASA's house, perhaps, but there was no evidence to show that he was unfit in any way, that he didn't have appropriate living arrangements, that he couldn't care properly for the child, and that there was any risk of harm leaving the child in his care. So this case got reversed, and the child was then removed from the grandmother's custody, which was traumatic for the child, and moved back to the father where the child stayed. And then at this point, when the CASA recommended non-reunification, the case was only 4 months old. So the CASA was recommending one of the most drastic solutions: don't provide any reunification services for this father. He'd only been in care for 4 months and hadn't even had a chance to show yet whether he was going to comply with a case plan.
Yeah, so we're really just trying to highlight this because this was not a situation where the CASA was not doing their job. In fact, above and beyond, the CASA was meeting with the child weekly, right? Yeah. And having had the opportunity and permission from the local CASA program to kind of review the CASA's notes and the court report, that the CASA was visiting the child weekly, and all the analysis the CASA volunteer was looking at was really about whether or not the child should be with the foster parent or whether the child should be with the grandmother, and completely discounting the parent's opportunity, and tried to reach out to the dad, and dad wasn't responsive, not returning a few calls, and basically just kind of wrote them off. And that just is just an example of showing why it's so important to be able to go back to those best interest factors, to go back to our guiding principles and looking at trying to maintain family preservation whenever we can. There wasn't really any contact with mom. So just remember that and what this is showing too is that how persuasive the CASA was to the trial court, that even without evidence, maybe it's hard, I didn't look at the transcript, but without a lot of evidence presented, was really swayed by that recommendation of the CASA and put so much weight on it, to the extent that that's the ruling that the court made. But when you actually get down to it and understanding the power that your recommendations have, it's why it's so important to make sure that your assessment is impartial, objective, and really looks at the best interest factors.
So when I saw this case, and the Court of Appeals said this CASA, there was nothing in the trial transcript to support this CASA's recommendation. I wondered, how did the CASA support this recommendation in the CASA report? So I contacted Angela and said, let's get the CASA report and look at it. And just as she said, the CASA was completely focused on whether this child should stay in the current foster home or go to the grandmother. There was no consideration of the father. And it just looks like is because the CASA just didn't like the father. And sometimes you're going to have to recommend return to people that you don't want to have over to your house or that you don't like. But the evidence doesn't support the recommendation. There was no evidence. So what this CASA was doing was going on a gut reaction in this case, which ultimately derailed a child's permanency by probably a couple of years by the time that case went up on the Court of Appeals and got returned. So that the child spent time with the grandmother, then got removed from the grandmother and sent back to the father again. All of that completely unnecessary because there was no evidence to show that the child was dependent in the father's care. So,
all right. So I'm gonna
really
reel you back in on some of that. We have about 15 minutes left and about 10 slides to look at a GAL's ubiquity and presence in court and testifying.
Yep.
So I'll turn it over to you.
One of the things that we have to say is that the CASA ubiquity means that they're everywhere. Something's ubiquitous when it's present everywhere. Well, the GAL is required to attend all hearings and all other proceedings related to the case. So that includes hearings, panel reviews, if you're in a jurisdiction that uses citizen panels, bench conferences where the lawyers go up to the bench and talk with the judge, conferences in chambers where they go to the judge's office to talk, anything that could result or affect the outcome of the case. The CASA or GAL should be there. Right? If they're up there doing legal arguments, then maybe you don't have anything to add. But if they're up there talking about a possible settlement of the case or a possible exclusion of the child from the courtroom during a particular part of the hearing, you have to be involved in all of those things because you have to be able to tell the judge why you think this proposed outcome is in the child's best interest or not. So
I'm gonna just pause and interrupt to remind that some of you guys might be sitting there like, wait, participating in all these things. When I go to court, the court doesn't even call on me to make a recommendation. This isn't my experience of what being a CASA in court looks like, right? And that goes back to why we wrote this and what we're trying to do when we have these same conversations with our court audience and trying to make practice look this way, because what you see our code section up there, right? The code requires these things and making sure that across the state, the GAL's inclusion looks the same. The big takeaway is that to the extent in your juvenile court that you are invited to participate and have the opportunity to do so, that you take advantage of those opportunities. It goes back to when I talked about the 17 roles and responsibilities and the importance of attending court and being there. In virtual land, it means being on the virtual platform, that when your hearing is called, that you're showing your camera and able to participate to the full extent in the virtual proceedings as well. So I had to make sure that I paused to say that, because I think that's one of the things with these presentations. We talk about how it should look and how it's required to look by law, but sometimes it not quite the practice in a local place.
We had a question about what we mean by dependency. That's important because we've been talking about this the whole time. So a child is dependent. You have a case of dependency when a child is abused or neglected or is in imminent risk of abuse or neglect. And that means that if the child has any parent who can adequately care for and protect the child, then the child's not dependent, right? So you may have two parents. Maybe they live alone, separately, maybe they live together. The question then becomes, can one parent protect the child from the other if it's one parent who's the problem, like it was in that last case, in the JG case, right? The father moved out. He wasn't living with that mother anymore. So the child had been abused or neglected, but by the mother, not by the father. If the child has a capable and willing parent, then the child's not dependent. So dependency means abuse or neglect that makes the child too great of a risk to remain with either parent. Because if the child can go with one parent and not the other, then the child's not dependent.
Right, and triggers the jurisdiction of the state and the juvenile court to oversee what's going on. Another question was, we were talking, and I skipped ahead because I'm watching the time here, about the proceedings that the CASA or the GAL includes or could be participating in. On the purpose of this slide, because we're talking about courtroom advocacy today, we were really talking and only kind of highlighting the hearings and the panels and mediations, things like that. But yes, your court order and your role as GAL, the reality of the situation is you're probably advocating more outside of court than you are inside of court. So attending IEP meetings or meetings at the school, being in family team meetings, permanency roundtables, or other staffings at DFACs would all be appropriate and really necessary in order to gain that full perspective and making the independent assessment. So go to independence, and then we've got about 10 minutes.
So the GAL has to be independent if the GAL is going to truly be impartial. The GAL can't fully investigate, do what the code requires the court to do, the GAL to do, and make an impartial, objective recommendation to the court if the GAL is concerned by fear or favor from a party or the court. So the GAL can't say, oh, if I make this recommendation, the judge is not going to like it. You know, that may be the case, but that's not your concern ultimately. If I make this concern, this DFACS is not going to like it if I make this recommendation. Well, that may be the case, but your job is to fearlessly and without favor or partiality to make recommendations in the case. Someone in the courtroom is probably not going to like any recommendation you make. Sometimes GALs seem to be much more comfortable with the parents not liking them and a lot less comfortable with DFACS of the judge not liking them. But remember, you don't belong to any of those parties and you don't belong to the court, right? You owe a duty of independence and objectivity to all the parties and the court. And you are not beholden to any of those parties or the court. You have to make your objectivity and independence a paramount concern. Sometimes GALs have to get on the witness stand and testify. Our code says that the parties or the court can require the GAL to come and testify on two separate occasions. This first one is simply saying that they can be required to come to court and testify as to the appropriate disposition of a proceeding. That means the outcome. Where should the child go? What should we do in this case? So this just means that if the GAL is not, we just talked about how the GAL should attend all hearings. If the GAL is not doing its job or his or her job, the court or any of the parties can require the GAL to stop doing whatever the GAL is doing and come to court. Now, CASAs are volunteers. Some of you have lives outside of your CASA world and you have things you have to do. But you have to remember that you're a necessary person to the continuance of the case. And personally, as a judge, if the listed CASA did not appear for court, I would continue the case. I would stop and I would say, where's the CASA? Why isn't the CASA here? Because even though there may be occasions where the staff person could talk about the CASA's recommendation and help get the report across to the parties, that staff person was not the one who talked to everybody and not the one who did the investigation. And the parties have a right to hear from the CASA. And the CASA also has to talk about how the information that comes out at the hearing affects their recommendation. So really important. So that's one thing that the CASA can be compelled. The CASA can also be compelled, even if present, to get up and sit on the witness stand and take an oath and testify. GALs are not primarily witnesses. They're there to advocate for an outcome that's in the child's best interest. So when can they be called to the witness stand? So the other code section that deals with this says that as long as the GAL is not also appointed as the attorney for the child, that GAL can be called as a witness for the purpose of testifying to the rationale for your recommendation. So sometimes GALs get up and say, I recommend that the child stay in foster care. And they don't say why. Good courts, diligent courts, should ask the GAL, why? Tell us why on the record you didn't want the child to stay in foster care. But if that doesn't happen, the parties have a right to say, Judge, I'd like the GAL to get up on the stand, take an oath, and explain to us under oath why the recommendation was made. Again, this really shouldn't happen very frequently because you should be making very clearly the rationale for your recommendation. But if you don't, again, if you don't come to court, they can make you come to court. If you come to court and don't provide an adequate background for your recommendation, they can compel you to do that. So what if you do get called to the stand or just questioned in open court about your recommendation? There are some things that you can do that will really undermine your credibility with the court. That is, the court's leaning towards relying on you and believing the things you do and say. So we've talked all through this presentation about how you need to be objective, right? You're just not there to tell the court what you feel. You're there to tell the court what the best interest factors demand based on the evidence in the case, even if you're uncomfortable with it. And just talking about your feelings on the stand is not helpful to the court, okay? And it's not helpful to the parties. It doesn't explain your rationale. So it shows that you're being too subjective. In the same vein, being too emotional. Now look, I mean, Angela and I are lawyers, and I used to be a prosecutor, and I've dealt with child molestation cases, horrible murder cases. I've done all those things as a SAG. I've heard them all as a judge. We get somehow a little bit, sometimes we get a little desensitized to the sort of horror of some of the things that our children go through. It's natural to have an emotional response, to get upset sometimes for the things you see and hear in court. But you don't want to be so emotional that you can't communicate it clearly with the court about what's going on. And you don't want to get emotional and defensive because you're being asked questions to explain yourself. As long as you can give a credible explanation for your recommendations, then you shouldn't be defensive when you're asked questions about them. The parties have a right to know those things. You don't want it to come across that you're aligned too closely with any party. A lot of times CASAs seem aligned with the foster parents. I suspect sometimes that's because of a sort of unconscious bias that perhaps the foster parents sort of live more on a level that the CASA lives on, maybe, I don't know. But we don't want to penalize people because of poverty or any of those sorts of issues. We want to be clear that we're being objective. So those are important things.
How
I know
we
we got to
increase
hurry
it.
up. Yeah.
No, just how it was on the flip side, like how do we increase
on
our
the flip
credibility?
side, you can increase your credibility as a witness and an advocate by listening closely to the questions that you're asked and only answer the questions that are asked. Even if the answer makes you uncomfortable. Someone may say, hey, you never talked to Joe Smith, did you? And the important thing is not to sort of prevaricate and say, well, let's just say, no, I didn't talk to Joe Smith. And here's why I didn't do it. Maybe I should have, but I didn't do it. You just simply have to answer the question. And I don't know, and I don't remember, as long as they're true, are perfectly appropriate answers. It's never wrong to say, I don't know the answer to that question. I just don't have an answer for it. That's appropriate if you don't. If you're asked a question to which you don't know the answer, it's totally truthful and appropriate to say, I don't know the answer to that question, or I don't remember that, or no, I didn't do that, or yes, I did do that. The main thing is to be factual, stick to the facts, acknowledge the things you see in the parties that are good, acknowledge the steps and strides that have been made by parents, children, and defects, and don't be afraid to stop and think if you need to answer a question. You can even say, Judge, can I have a minute to review my notes so I can answer this question appropriately? Don't think that you have to answer immediately. So don't be afraid to sit and think for a minute too. Those things will only increase your credibility with the judge. If you're on the witness stand, the code says that you're to be called for the specific purpose of cross-examination. So that means they're going to be, the attorneys are going to be asking you questions to elicit answers about why you've come up with the recommendation. And they can ask direct questions like, well, tell us when you saw the child last. You need to be prepared to answer questions about any aspect of your work, how often you've seen the child, how often you've observed parents and children together. A lot of times we see guardian ad litem's making recommendations for no further contact with the parent or child when they actually haven't observed the parent and the child together, which hurts your credibility when that happens.
Which was the case in JG,
which was
right?
the case in JG.
If there had been a zealous, either mom or dad's attorney had been zealous in their advocacy,
Yes.
They should have had the CASA on the stand and really been asking these questions to prevent the court from ordering finding the way they did.
And again, making it clear that you've considered the compliance of all of the parents and defects with the court orders, that you're not just there to say gotcha to the parents, they didn't do this, they didn't do that. Defects has a requirement to make reasonable efforts on the front end to prevent removal, and after removal to allow the child to return home or to whatever the permanency plan is ordered by the court. And so one of your jobs is to frankly evaluate defects' efforts to do that. And you need to be clear. Judge, defects hasn't done all they should do in this case, if that's what you believe to be the case. Or if you've seen them doing good, to point out the good things that they've done in the case, but also the good things that the parents or the child have done as well. So you need to be prepared to address any aspect of your work as a guardian ad litem when you're called to the stand. Nothing's off the table. And the only questions you should refuse to answer are questions that the court allows you to refuse to answer. You should go ahead and answer any question unless a party objects. So.
Well, we are finishing right on time, about a minute to spare, right? And hope that over the course of the last hour and a half, we've really helped to maybe re-emphasize to you that uniqueness and the power that your role holds as a GAL and a CASA, and kind of remotivate you to get out there and your advocacy, especially at a time during COVID when other services and things might be declining for the child or family, that we can really be standing in the gap and helping to connect the dots and share information and make sure the child's case stays on track and doesn't slip through the cracks. And just the importance of our best interest advocacy and the court's findings. And hopefully through a not so good example, really able to show that importance of being objective and impartial, and using those best interest factors, remembering our guiding principles to our advocacy. So we're right at 4:30. We will stay on for anybody who has questions for us we might have missed in the chat or didn't have time to catch, but you can also email us. Somebody said, how often are we going to do these trainings? We our CASA conference will be this summer. We already have in our mind a couple of other workshops for the spring. So we look forward to seeing you guys again.
I did see a question a second ago.
Oh, you did? Okay.
Yeah, hang on. Let me see if I can find it again. Let's see.
There was another question about being in meetings with foster parents and DFACs and those others, right? And I know that we missed that one. We kind of answered a related question about just the CASA's ability to advocate and be present in all those proceedings and meetings and really help to, like I said, connect the dots and sharing that information.
We did have a question about what do you do when the GAL and the case manager don't want you involved in conversations prior to your case being presented. Well, of course, you are the GAL, so you must mean like an attorney GAL. It doesn't matter. I mean, you've got to get that information to the court. If someone is stymieing your ability to attend on meetings and find information out, you got to talk to your staff and get that information to the court in the context of the next hearing. Judge, I can't make a recommendation because DFACs won't talk to me. That's a perfectly appropriate thing to say. I haven't been able to gather the information I need. There may be a way, working with your staff, that you could communicate that to the judge and all the other parties at the same time prior to the hearing, and maybe the judge could do something about that in the meantime. But you need to make sure you're handling that appropriately and that you're not having one-on-one conversations with the court.
And of course, we would want to, any of these, and I'm sure you guys have lots of questions about when so-and-so doesn't want me to, I had a question from my CASA the other day, the parent's attorney doesn't want me to talk to mom or dad without them being present, and how to, advocate in those situations and trying to handle it at the lowest possible level outside of court as soon as it can before it kind of snowballs into a bigger issue is always good. And that's what your coordinators are there to help navigate, that they have those professional relationships with the stakeholders and help to navigate those.
Here's a really good question. Confidentiality, if you invite relatives and foster parents to court and they're there, are they in the bubble?
Ooh,
well,
that's a good one.
So they're in the bubble as long as they're in the courtroom and for anything that the court allows them to hear. Okay.
But that doesn't mean outside of court you're sharing
outside of court. You can't go outside of court and talk to them about those things. They hear what they hear. They see what they see. They're hearing it in the context of the court proceeding. They're not hearing it one-on-one from you. Okay, that's the big difference. So our dependency courts are presumptively open to the public, which means that anybody could just show up and sit in and watch a hearing, assuming we're not doing these virtually, because they're open to the public. And so anything they hear in the course of that thing, they hear, right? And it's not a violation of confidentiality because the court has made a determination and the legislature that these hearings should be open to the public. But that's different than you then going outside and saying, okay, now that you've heard some of this evidence, let me tell you blah, 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 blah. You can't do that. You can't communicate with them. They can hear what happens in court, but that's the extent of it.
Let's distinguish, though, from the times when a relative or a foster parent has gotten an attorney, has filed the appropriate paperwork, right, and has intervened and has been joined as a party.
Right.
If that's the case, then they're able to access that same information that you're sharing with the other parties. But
if you have a doubt, you should ask the
yes.
court, judge, is this relative now a party? Can I share information with them? Just get your instructions from the court about those things.
All right.
There was one other question.
One other question we missed.
Can't find it because we have so many.
I know.
We have so many of them. I did see one that asked who puts the factual information into CPRS. Most of the factual information in CPRS comes from the Shines system. So we get information from the DFACS data system, which is called Shines, every day. So it's as accurate as Shines is. So that's usually the case manager who's putting that information into Shines, and then we get it as well. We can update CPRS with information that Shines doesn't have, like, for instance, your CASA report or other things that the court puts into CPRS, or court orders or things like that. So we may have more information than Shines has in CPRS, but the basic information comes from DFACS. So
there was also a question about using information that you gather on social media and other things. I mean, all that is information that you've gathered and you can use to support your recommendations, but just keep in mind that at that adjudication and TPR hearing, that kind of information might be harder to get in. But you can work with your coordinators about the appropriate way, or ask your child's attorney if they're also serving in a GAL function for the best way to get that information into the court.
Here's a really good question. What's the legal protection for sharing information with the foster parents for the purpose of educating, for education and medical issues? The example given is a psychological report. Well, first off, you still can't share that information directly with the foster parent without a court order to do so. The foster parent is entitled to have a copy of those portions of the case plan that deal with the child. Most of the time, they don't actually get those. One of the things you can do is to advocate for them to have that, because if they have the portions of the case plan that deal with the child, they're going to know what the medical issues are and what the educational issues are. The other thing you can do to help educate foster parents, they have a right to notice of every court hearing, and they have a right to attend the court hearing. They're not parties. They don't have a right to be represented by a lawyer, but they have a right to attend, to listen, and to make a statement to the court. So if they come to court, they will also know about what's going on with the child's needs in every area of the child's life. So the best thing you can do for the foster parents is not give them information unilaterally, which can get you into trouble, but to advocate for them to get the portions of the case plan to which they're entitled, and advocate for them to get notice of the hearing so they can come, neither of which happens in a lot of our state, even though it's in the law. So that's a really good question.
All right. Well, now we've kept a couple hundred folks 7 minutes later, and we could do this all day. So, but thank you guys. And Regina, I think we can stop broadcasting.
Please email